Hey, my name is Shaunak, rhymes with Sonic. I've been a plaintiff's litigator for almost 10 years, which means I represent people, usually against corporations or government entities, and I love the law. I love using it to fight for people every single day. And today I'm going to talk to you about the truth. You may see jury trials on TV or in books, and you may wonder if this is supposed to be about the truth. Why doesn't every piece of evidence make it to the jury? Why are things excluded? Well, it's actually because the point is not to get all the truth, but to get the relevant truth, to get the things to the jury that matter for the case at hand. So today I'm going to talk to you about the law of evidence. There are three big gates or filters that decide what reaches the courtroom, what reaches the jury. The first one is admissibility of evidence. What information can actually get back into the jury room? The second has to do with the types of questions that are asked at trial. What kinds of questions can you ask when there's a witness on the stand? And the third has to do with privileges and immunities, certain laws that are in place to shield any information from even getting out in the first place. We can break admissibility down into four general buckets. They're relevance, reliability, fairness and prejudice, and deterrence. Relevance is a super critical threshold here because the information you're trying to get into trial to the jury needs to be relevant to the case at hand. It has to have some tendency to prove or disprove a disputed fact, go towards the claim or the defense that one of the parties is raising. Say you had a trip and fall case in a supermarket, and the supermarket's attorney is trying to get in evidence that the plaintiff had a DUI 5 years ago. That's most likely not going to be relevant to the case because it has nothing to do with proving an element or a fact that's in dispute relating to how this person fell or how this person was injured. Now, maybe if they brought evidence that this person was injured in a DUI incident 5 years ago and hurt their back in the same way that they hurt themselves when they fell, that could be relevant in showing that the damages, the harm, did not all arise from this one incident, but was relating to pre-existing harm. But in that case, the DUI itself, likely not relevant, really only the fact that there was a prior injury would be relevant. Now, a key distinction to remember is that the standard for relevance can be much broader in discovery than it is at trial, right? Trial is sort of the end of the road. It's where you get at the end of the case when you're ready to talk to a jury or a judge and tell the story and give the evidence and prove it or disprove what happened. Discovery is the process. It's the journey of gathering information along the way. And discovery is made up of written requests for information, depositions, sit-down interviews with witnesses and parties in the case. The goal of that discovery process is discovery. You're trying to discover evidence. In California, the standard for relevance in discovery is not whether it has a tendency to prove or disprove a disputed fact or an element of a claim in the action, but rather it is if it is reasonably calculated to lead to admissible evidence. That is a much broader standard, right? Am I asking for information that it itself may not be admissible, but will lead me down the path of figuring out some admissible evidence I can use at trial? The second bucket here in admissibility is reliability. Evidence must be reliable in order to be admitted at trial. What does that mean? You may have heard of hearsay. Hearsay is an evidentiary rule that has to do with the admissibility of out-of-court statements, because generally speaking, out-of-court statements that are being repeated, secondhand statements that are being repeated, are less reliable than hearing it directly from the witness themselves. So if I say, Jim told me he saw the collision happen, well, that's less reliable than Jim just saying, I saw the collision happen. And you can get multiple layers of hearsay that become exceedingly unreliable as you go down the chain. Jim told me that he was talking to Emily when they overheard Sarah talking to Tom about Tom's neighbor, because Tom's neighbor told Tom that he saw the accident happen. We're getting down a really complicated chain of hearsay here when the neighbor testifying what the neighbor saw would be the most reliable way for the jury to get that testimonial evidence. And then there are exceptions to hearsay, instances where it's still hearsay, but it's admissible because we have said as a society, those types of hearsay circumstances are inherently more reliable than just your everyday normal hearsay. For example, the business records exception in a lot of jurisdictions is an exception to the hearsay rule. If certain documents are kept in the regular course of business, then those can be admitted even if they're hearsay, even if they are out of court statements, because generally speaking, keeping things in the regular course of business comes with it an additional layer of reliability than somebody told somebody else who told me. Another important piece for evidence to be reliable and therefore admissible is that it needs to be real. It needs to be authenticated. The jury needs to know that that evidence is the real deal. It is what the lawyers are saying it is. If you're trying to get a photograph into evidence, for example, the person who took the photograph could authenticate it. They could say, I was here on January 4th, right outside the shopping center, and I took this photograph. They have authenticated the document. This is a true and correct copy of the photograph I took on this date. Now the jury knows that this photograph is what it appears to be, what the lawyers are saying it is, because the person who took the photograph has told us that under oath, under penalty of perjury. Now, the fourth bucket under admissibility is deterrence. There are certain rules of evidence that exist solely to prevent people from acting badly. I'm talking about fruit of the poisonous tree, which is a great name for a really, really important doctrine. This is the doctrine whereby if evidence is obtained by an illegal search, then that evidence cannot be used at trial. It is not admissible. It is excluded. You're watching a lawyer on TV and all of a sudden they jump up and they yell, objection. That's an objection to the form of a question. Now, why does the law police the types of questions I ask and the way I ask questions? It's because I'm very good at asking questions. And I'm very good at asking the questions in a way that I get the answers that I want. The law provides a protection. It's a safeguard to make sure that information that the jury is getting from a witness is information that is clear, information that is not prejudicial, information that is not the result of a confused witness, and is not a time when the lawyer is arguing to the jury, because the lawyer is going to be able to do that at closing argument. Now, the types of questions that are objectionable can differ based on whether you're asking questions on direct examination, which is asking questions of a friendly witness, or on cross-examination, which is asking questions of an adverse or a hostile witness. And the reason is because the goals of those two examinations are different, and the relationship between the attorney and the witness is different. If I'm doing a direct examination of my client, the plaintiff in a case, that relationship is a relationship of trust. And that means that that person is going to be far more likely to agree to what I'm saying rather than to push back. Which means if I'm asking leading questions of my own witness, it's far more likely that I'm going to be able to basically testify through that witness to the jury because they're not really going to push back. And that really becomes more of the lawyer telling the lawyer's story, or the lawyer telling the story they want to tell the jury, which again is the time that closing argument is for. That's why on direct examination, leading questions are generally prohibited. You ask open-ended questions. You let the witness testify in the way they're going to testify. Now, on cross-examination, you flip the script. Because if I'm examining an adverse witness, people sometimes call a hostile witness, that person, there's no love lost there, right? There's no trust, there's no relationship. That person is going to want to push back against the questions I'm asking. They're going to see all the questions as a potential trap, and they don't want me to get to my goal. Leading questions aren't going to be effective in sort of testifying directly to the jury because that person is going to push back if there's even the slightest thing that they think is wrong, or they think should be framed a different way, or they think makes them look bad. And so it's okay to ask leading questions on cross-examination. And in fact, it's encouraged because that's the way you're going to get the information that's important for the jury to hear. Another example of an objectionable question is one that's compound. You met with HR, you signed the release, and you got paid, correct? You're asking three different things. And if the witness just says yes, then later on when the jury reads that transcript back, they're going to assume that yes is to all three. But maybe the witness only heard the last part, or maybe the witness was only thinking about the last two things you said, because you said so many things they forgot about the first thing. And so now you're getting an answer that isn't really accurate, but it's the one that gets preserved in the record and the one that the decision is based on. And so the objection is intended to make the asking attorney go back and ask those questions one by one so you get a clear answer on the record for each of those questions. Another set of objections, vague and ambiguous. You handle that guy, right? If there's no foundation that's been laid for what it means to handle somebody, especially in the context of that witness, then what they did may be unclear from their answer, whether it's yes or no. If the foundation hasn't been laid to establish who the guy is that you're talking to, if there are multiple people and you haven't established which guy you're referring to, that answer, especially read back on a transcript a day, 2 days later, the jury may not really remember or be able to figure out who that's referring to. Another objection is assumes facts not in evidence, also related to lacks foundation. After you stole the money, you went and stashed it in the blue VW, right? What I'm doing there is I am forcing the witness by answering to adopt a premise, which is that they stole the money in the first place. And the lawyers don't get the answers they want. Sometimes they ask the question again and again. And at a certain point, that becomes a harassing question, and your witness, especially if they're a witness who might be intimidated by repeated questioning, if they're anxious, if they're younger, they might change their answer because it's scary to be asked a question by an attorney over and over again, like you've done something wrong, even if you haven't. Another objection, one that every family member of a litigator will be familiar with, argumentative. This is not the time or place to debate the witness. How could you possibly expect the jury to believe that ridiculous story? Objection, argumentative. It's not enough just to make the objection. And that's what the judge is there for. In a trial, the judge is the one calling balls and strikes. They are the umpire, the referee. They are the gatekeeper. And they decide. And oftentimes the judge will overrule an objection because they've evaluated it there and said, that was a proper question. Or they'll sustain the objection and the attorney will have to reframe the question or move on. There's some information that doesn't see the light of day. It's like locked behind a vault. That's information that usually comes out of communications in confidential relationships. Attorney-client privilege. It's important for people to be able to have truthful and frank conversations with their attorney, seeking legal advice, talking about a case. And we don't want to invade that privilege because that would ruin the ability of people to trust their attorneys. Clergy penitent privilege. If somebody goes to their house of worship and they want to have a confidential communication with their pastor, their rabbi, their imam, and they want to do it, for the purpose of absolution or spiritual health, we as a society feel that that's important. And that's why a lot of jurisdictions have this privilege. Information from that communication can't be subpoenaed, can't come out at trial. Spousal privilege is another privilege. Communications that are made with a married partner, those are confidential communications. As a society, we believe that confidentiality between two married partners is very, very important and sort of sacred. And so there is a legal protection that's offered to those communications. There are times when any of these privileges can be waived or where they don't apply. One exception that's maybe well known, and it's an exception to the strongest privilege, attorney-client privilege, is the crime-fraud exception. It's one thing to go to an attorney and tell them you've committed a crime. That's privileged. But if you tell them that you are going to commit a crime and then you want to use their advice to commit a crime, that's a situation where in a lot of jurisdictions, there is an exception. The lawyer is then allowed to go and report that. Because as a society, we believe that people should be able to tell their lawyers the truth, but they should not be able to use lawyers who are extremely sophisticated in the laws to break those laws. In a lot of jurisdictions, there's also a mediation privilege or a mediation confidentiality. And the point of this is so that if you're in a mediation with the other side and a neutral mediator trying to resolve the case through a compromise settlement, conversations you have over the course of that mediation don't leave those closed doors. When we're in litigation or we're in trial, both sides are putting forth their best facts and their best law and arguing that their position is the right one. And they're both doing it to the best of their ability, and the court then makes the call based on all of that argument. That's how the adversarial system works. In mediation, when you're talking about settling a case, we want people to be honest about the risks of litigation. They may believe their side is right and supported by the law and the facts, but we also want them to recognize there is a risk they could lose. There is a risk they could be wrong. There is bad facts. There is bad law. There is a risk the jury may not like the client. There is a risk that they could win, but the amount of money that they might end up getting wouldn't come close to what they have to expend to get there. We don't want an acknowledgement of risks then to be taken out of context and used against somebody outside in trial or in litigation. We don't want someone to take something you've said in mediation saying, I acknowledge that a jury may not like this fact, and then the other side to come and beat you over the head with it at trial. Bottom line, as a society, we think it's important for people to be able to try and settle their differences without having to go to trial. And this facilitates that. If that was interesting to you and you're kind of curious, not just about what evidence, but who can bring that evidence, then you might like this video I did on standing, which is all about who can bring a case to begin with. Otherwise, I hope you thought this was interesting, and I'll see you next time.